From the initial filing of your ex parte order to the actual time you get into court, it could take several days or up to 10 days. And I always encourage my clients to make sure that they come prepared to court. I know at this present time, there's a bunch of emotions. You're angry, you're sad, you're terrified, but it's important that you get everything organized so that you can come to court prepared to present to the court and let the court know that you are in fact a victim of domestic violence. So it's extremely important to make a list. I always encourage my clients to make a list of what, who, what, where will explain to the court the actual acts of domestic violence you have suffered. So we want to make sure that we present to the court witnesses, doctors, Department of Social Services workers, teachers, friends, family members that have actually seen the domestic violence, seen the effects on you and your children, seen the bruises, witnessed the actual acts of domestic violence. These are the individuals that will lend a lot of credence to your case. And it's important that you make sure that these witnesses are available. And number two is that they know why they're coming to court. They need to know what is relevant and what they need to tell the court. And it's important that they understand that they're in front of the court or the judge to explain the acts of domestic violence. Nothing less and nothing more. That's what the judge wants to hear. They want to hear the relevant facts of domestic violence, why you're fearful of this person, and that you in fact witness it. And that's going to give a lot of credibility to your case. Documents, pictures, texts, photos, I always encourage my clients to make sure that they have copies and bring that to court. Those documents, photos, or records. Those documents will help and assist you in presenting your case to the judge. A lot of the documents, especially if photographs, especially text, will document and be able to clearly indicate to the court what he said, what effects you had, and what type of words he used against you and your children. So I think it's always important to make sure that you have these documents with you, and if at all possible, I encourage my clients to make sure that they take multiple copies of these documents and records to court, one to present to the defendant and also one to present to the court as evidence. It's also extremely important that any witnesses or evidence, paperwork or pictures, are relevant to the current situation. We need to be able to tell the court that this person, this witness, this document will explain to the court exactly what has happened. I think and I believe that a lot of times if you present extraneous, irrelevant information, I think the actual message will be lost, and there's a lot of confusion that would be presented, and the court needs to make sure that they understand. And I always tell my clients KISS, which means keep it simple and specific. So we want to always present a picture, evidence, facts that are simple and specific. Now that after you've filed the complaint, you'll have an opportunity to present your case in front of a judge. But even before you present your case in front of the judge, there's some rules and regulations of the court that you must follow. Most of them are basic and self-explanatory. I always encourage my clients to arrive on time. Definitely before the calendar call in any case. Make sure that you arrive at least 15 to 20 minutes in advance so that you'll have an opportunity to get familiar with your surroundings, and make sure you do sit away from the defendant. Never, under any circumstances, should you ever sit beside the accuser. I would also encourage you to make sure that you have all the documents copied and prepared. Make sure that all of your witnesses are present, and make sure that you have all of your documents together ready for submission. It is also important to make sure that you do not, under any circumstances, leave the courtroom until a break or until you are directed to do so by the judge or an attorney. There are many times where I'm having to look for a client because they've stepped out to the restroom without telling me, and our case has been called. When you come to court, I always encourage my clients to come presentable. This is not a fashion show. This is not your living room, nor is it your gymnasium. You want to present to the court that you want to tell the court and represent to the court that you respect the court, you respect the judge, and you also respect yourself. You want to come business casual. I always suggest to my clients a simple blouse, a simple skirt would suffice. I would definitely discourage any types of tank tops, pajamas, or even sweat tops. When the court calls you in front of him or her, I always encourage my clients to make sure they come immediately to the table. Usually, when you're facing the judge here in Alamance County, the table you will be required to sit at is the table on the left hand side. So immediately go to the table, the respective table that you are assigned to, and make sure that you are ready with all your witnesses and your paperwork. Make sure when you address the court that you say, yes, ma'am, no, ma'am, yes, sir, no, sir, yes, your honor, or yes, judge. Now, it's important to impress upon the court that you respect them and that you understand the etiquette and the procedures of court. It is also important that when you respond to the judge, that you don't say or yeah or what. This is the individual that will be listening to your case, and I think it's extremely important that you make them aware that you respect the court and that you understand the procedures. And when you're talking to the court, I always encourage my clients to make sure that there's direct eye contact. I know you're nervous, I know you're scared and frightful, but I think it's extremely important that you look at the judge, you look at the court in face to face, that you're able to explain to them exactly what has happened in the domestic violence and the issues that you're going through. And by looking at them directly and making sure that they understand what you're saying will definitely help your case, and will definitely the judge will be able to understand exactly what you're saying. A Rule 65 is a court order telling the defendant, do not harass, assault, interfere with the plaintiff. And this is filed in civil court, and it is a civil order. If the defendant harasses, interferes, or assaults the plaintiff, the victim will have to file a motion in court, wait for a court date, request a court date, and present all the evidence in court, and ask that the judge find him in violation and in contempt of this court order. This is completely different than what a 50V protection order will grant you. If the defendant harasses, assaults, or interferes with the victim, all the victim has to do is contact the police. The 50B will already be registered with the police. The 50B will allow the police to act immediately and arrest the defendant. This gives the plaintiff relief and protection that the 50B will cover. And the 50B, again, will cover the plaintiff and or the child. A subpoena is used to request someone to come to court or request someone to bring the documents to court. The subpoena is one form, back and front. It's basically a form requesting the person to appear in court. Now, you always want to subpoena a person who is going to be relevant to your case, who is going to be able to tell your side of the story, that is going to be able to tell the court, this is what the defendant did, this is how he did it, and I was there. I always encourage my client to subpoena only relevant people, only people that will help and bolster their case. And make sure that these people know you want them to come to court. A lot of witnesses are reluctant to come to court because they know both the defendant and the plaintiff, and they just don't want to get involved. Make sure that you inform them that you will be subpoenaing them. Now, the subpoena can be found online or on the AOC, the Administration of the Court's website, and it is Form AOC G100. Please make sure to always complete the document as thorough and as accurate as possible. You need to state your name, the defendant's name, and make sure you have, when you're calling a witness or requesting a witness to come to court, make sure you have their proper name and their address. Once you complete this form, you need to bring it to the clerk's office where you need to pay, and they will issue the subpoena to the individual. You will have to pay for the service. Usually the police officers or sheriff's office will serve the subpoena. This is basically a notice to the witness to come to court. On a subpoena, you can also request the individual to bring items such as videos, photos, statements, reports. Any items, documents, reports that will help present your case will always be beneficial. When you get these documents, reports subpoenaed, you also have to share them with the other side, and that's also part of the rules. You need to make sure that if you subpoena somebody or someone or something or someone to bring these items to court, you need to make sure that the defendant has a copy of the subpoena so he or she is aware of what or who will be coming to court. During the hearing, you will have an opportunity to present your witnesses and cross-examine the defendant's witnesses. When you call your witnesses to the stand, you have to make sure that these witnesses are relevant, that they've seen the domestic violence, heard the domestic violence, were present during the domestic violence, or you told them about the domestic violence or the professional that has been treating you. So these are the types of individuals or witnesses that would definitely be beneficial for you to bring to court. When you bring them to court and place them on and call them to the witness stand, you're limited to only asking direct questions. You can ask who, what, where, how, and when questions, and describe questions. You cannot lead them. You can't ask, well, didn't this happen? Didn't that happen? You'll have an opportunity to ask other questions. You need to keep these questions simple and specific. You need to make sure that the witnesses, be it the doctor, the teacher, or a child, that they're able to tell the court exactly what they saw, what happened, and make sure that they're able to inform the court that in fact that you were a victim of domestic violence. Now, you will also have an opportunity, if the defendant so chooses, to cross-examine the defendant or any of the defendant's witnesses. If and when the defendant comes to court and takes a witness stand, you will have an opportunity after he presents his testimony to the court and ask him questions. Ask him questions about what happened or what didn't happen. And at that time, you, the victim, the plaintiff, will be able to ask leading questions. You'll be able to be a little bit more aggressive. Isn't it true? Didn't you do this? And you will have the opportunity to be able to ask these questions more aggressively and more pointedly so that you will have your issues and your concerns and the actual acts of domestic violence brought forward the way you want them to be presented. The custody of minor children or a child can also be considered in a domestic protective order. The court or the judge will look at whether or not it's in the best interest of the children, and most importantly, if the child is exposed to substantial risk of physical, emotional, or sexual abuse. When there is a request or a request for the relief of custody of the minor child, the court is going to look at various factors. They'll look at whether the child was present. They'll look at whether the child has been exposed, whether the defendant attempted to cause emotional or physical harm to the child. If these are listed, or these are documented, or these are placed and documented in the complaint, the court can and will consider custody. But custody in domestic protective order is not always granted. I always tell my clients that they have to make sure that when they document everything, document the complaint, that they make sure to include what, if anything, has happened to the child, so that these factors, relevant factors, can be considered by the court. Now, if the court decides to grant custody to one party, then the court can also grant visitation if he or she finds it in the best interest of the children. I've seen various different ways the court will grant visitation. Sometimes the court will allow visitation to occur with specific times and places at centers like the Family Abuse Services, or to have the visitation supervised by a third party, such as a family member. I've also seen the courts do visitation or pickup at a center or at the police station. So the court can look at different various factors, different ways, and organize certain visitation schedules. I always encourage my clients as well to make sure if there's contact allowed only related to the children, that they specifically state that the defendant can only contact the plaintiff via text, give the text information, or via email, give the email information 24 hours before scheduled visitation. So we know specifically, and the defendant knows specifically, when he can contact the plaintiff. Also, if there's a contact allowed between the minor children and the defendant, specify the time, what number, and the duration, and specifically which hours. I think it's important that the defendant, if there's allowed visitation or contact, the defendant specifically understands the parameters, and that he sticks, and that also the plaintiff enforces this, the strict compliance of the visitation or telephone calls, so that there is a schedule and a routine for all the children.
This project was supported by grant number 2012 VAGX0060, awarded by the Office for Victims of Crime, U.S. Department of Justice. The opinions, findings, conclusions, and recommendations expressed in this publication, program, exhibition are those of the authors and do not necessarily reflect the views of the Department of Justice, Office for Victims of Crime.